Examinership, it's Ireland's rescue framework for otherwise viable companies that find themselves in difficulty, but they have a good prospects for survival if they can be restructured. In fact, the test actually is only a reasonable prospect of survival, subject to certain conditions. That if they can restructure themselves, they can still be there for the benefit, particularly of the employees, which is why the legislation was introduced in 1990. But secondly, then for the benefit of the community as a whole, that the enlightened approach is that businesses should have a second chance. They should be given a second chance if they can be viable, if they're restructured. So that's what examinership is. It was brought in because of the collapse of the Goodman the Goodman empire back in 1990, which represented 5% of Irish GDP in August 1990. But since then it's been used for, I think that the number now is approaching 1,500 companies over the course of the years, with a pretty good success rate, it has to be said. The majority of companies that have gone through examinership have emerged successfully and are still trading. So that's what it is. It's Ireland's Chapter 11 process, generally seen as being more management friendly than administration would be, for example, because it's a debtor in possession model, and the insolvency professional doesn't actually take over. The examiner is there to examine the business and come up with a scheme to allow for the survival of the business. That's what it's all about.
Generally, in your experience, and you've a lot of it in terms of examinerships, what's the success rate?
Well, first of all, going into court, you would see typically well over 95% of businesses that apply for examinership would actually secure the protection of the court. It's very, very rare that a business that's looking and that has an independent expert's report prepared, it has the evidence to demonstrate to a judge that they are a good candidate for examinership. Typically, the success rates in securing examinership would be probably 95%. Then coming out the far end, that really depends on the availability of investors. So if you take a sort of a broad average over the last few years, we've seen certainly the majority of companies, and I don't have the exact figures to hand here, but I understand it's of the order of 70 to 80% successful. And then even after a few years, the Revenue did a review recently, and they found that the majority of companies were still trading, even a number of years after they came out of examinership, which would demonstrate really that the process is working. Perhaps underutilized, because only about 2% of insolvencies in Ireland end up in examinership, and the equivalent rate would be about 22% in the US when it comes to Chapter 11. So it is an underutilized process, and probably little known, but I have a feeling just because of the current crisis, could well be that a lot more businesses have to get to know about formal protection processes and rescue processes like examinership.
Can I ask, Neil, do you have any insight or opinion as to why it's been so underutilized? Because that's something that's puzzled me for a long time. It seems that it would be an obvious choice for a lot of companies that have since gone into liquidation because they didn't pursue this avenue.
Yeah, I totally agree with you, Brian. I think that we should probably have rates similar to the US, because we do a similar sort of entrepreneurial type market-based economy. So there's no reason to me that it shouldn't be. But I think what has happened is that there isn't a huge amount of information about that in amongst the advisor community, say. And I know, for example, Leman Solicitors know examinership inside out. We here in Baker Tilly, we've done quite a few ourselves. But there are, I suppose, a lot of within the advisor community in Ireland, there are a lot of people who have not been exposed to turnaround processes and examinership processes. So they're not really in a position to advise their clients to do that. That's one reason. Second reason is sometimes directors leave it too late, and the doors are closed before they can actually react and try and deal with the situation. And then thirdly, in my experience, unfortunately, you have a sort of a pride issue that comes into it. And sometimes directors, particularly male directors, I found, are not really happy to put their hands up and walk in and say, I have a problem. I think maybe it's perhaps a curiously Irish male thing or phenomenon. You find, in fact, my experience, you'd find female directors tend to be much more practical, more common sense about these things. But that is an issue as well, certainly. And it seems like sometimes if an option is there just to wind the damn thing up, regrettably, a lot of Irish directors take that option where, there are a lot of jobs that perhaps could have been otherwise saved, because, the statistics show that well over 15,000 jobs have been saved in SME businesses in the last 10 years. And that's not including some of the bigger companies, some of the, for example, Aircom, some of these large company examinerships. Just looking at SME businesses, well over 15,000 jobs saved, which would have cost hundreds of millions to the state if the state had to pick up the tab for those redundancies.
We know that examinership can result in a successful turnaround for a company. So what can we do to overcome human nature and the pride that you're talking about in male directors?
Yeah, I think it might be a bit easier during this crisis. I think perhaps there's a lot of business owners now, this is their second very serious recession that they're going through. So I think maybe they learned a lot from the last time, and maybe they learned that you can't eat pride at the end of the day. Do you know what I mean? You can't you can't really be governed by that. You have to leave that at the door when it comes to making decisions in relation to the future of your business. I think it might be a bit easier this time. I think we do have to keep talking about it. And any opportunity I ever get, I must say, I always try and share our experience in having, been involved in 250 examinerships in the last, 15, 18 years, whatever it is. And some of the success rates we've had and some of the stories, when people actually see some of the stories, the fact that they do have a second chance. And okay, there may be other investors will come into the business. We always say to people, look, don't rule anything in, don't rule anything out, because you're on the verge of closure. So you need to have an open mind going into an examinership. But yeah, I think the more that we can talk about it, the more we can share those stories about what has happened, and some of the, I suppose, good news stories, the success stories, I think the more prevalent it will be and the more normalized it will be, and the people will start thinking of rescue first rather than closure. And people, we have to be in the hope business, guys. We have to give people a bit of hope and give them options when even they think that the thing looks like Mount Everest for them when they look at their creditor list. I mean, we need to be able to sort of say, no, actually, do you know what? If you break this down into some fairly basic steps, and if you put in place a rescue framework, such as appointing an examiner, a 100-day framework, a lot of other options will open up for you. So yeah, I think it's really, really positive, even really positive that, we're having this chat, because I think it should help if people are listening into us.
Neil, when you talk about rescue, I mean, the two things you struck, you said a company that needs to be rescued and the danger of directors leaving it too late. So if you're a company director and you're listening to this now, like, at what point do you say, I need to talk to an examiner? Like, would you be recommending people pick up the phone to you now, even if they're hoping to avoid examinership, they're hoping to avoid any intervention, but they need information so that in 2 weeks, 3 weeks, 4 weeks, depending on how this pans out, like, is now the time to start finding out more about this?
Well, I tell you what, I have a very clear view on that, Brian, because the first thing that people need to do is to create a model for the rest of the year, their base case about what does getting to the end of 2020 look like. And they've got to be realistic about that, because unfortunately, we've been talking to a lot of people who have taken, say, their 2019 numbers, and they've said, okay, we're going to be maybe 10% or 15% down on 2019. I mean, our view is that's totally unrealistic in terms of what's going on out there. What they need to do is they need to look at the key macroeconomic factors to try and to see what does 2020 look like for their business. And those factors are, unemployment is predicted to be somewhere between 12 and 15% by December. Okay, the PMI index, Purchase Managers Index, is well below 50%. And the Consumer Sentiment Index, the KBC run, that likewise has seen a massive drop. Now, the last time we saw statistics like that was in 2012. Okay, so if you're creating a model, and our advice to businesses, if you want to create that model to the end of the year, don't use 2019. That's gone. Like that, that was full employment. You need to go all the way back to when last we saw those kind of macroeconomic factors at play in Ireland, and that's probably 2012. So you need to take your 2012 turnover and map that into the projection to the end of the year and see what that looks like. And that probably is going to result in a real pinch point in and around June or July. That's likely the case from what we're discussing with a lot of businesses. And that means that you have to make decisions around the fact that you now have visibility on what the pressure point's going to be. And it could well be that this is an ideal time. And this is what we're hearing from a couple of clients, that this could be an ideal time during the lockdown to actually put in place a restructuring of the business, a formal restructuring. Because, for example, if you're construction, it means your site is already closed and it's locked up. If you're in retail or in a restaurant business, It means that there's very little disruption in terms of your trading, because you may have a kind of a skeleton crew in, depending on the business you have. It might just be a skeleton crew, or in fact, you may not be open at all. You might be planning for a reopening. So the planning needed for that reopening could involve getting the ingredients of a scheme of arrangement together, so that you have, this, when it comes to reopening, your list of creditors doesn't look like Mount Everest anymore. It looks like something that you can get over. You can scale that. You can try and just scale the mountain of debt that's in front of you. And that's, I suppose, some of the things we're hearing now from some of the clients we're speaking to.
I think it would be quite harsh for a court to start imposing retrospective penalties on directors during this crisis, but nevertheless, directors need to be cognizant of their duties to act honestly and responsibly.
Listen, I totally agree. I think what the difficulty for the directors involved, first of all, it's very, very difficult to plan, because we don't really know when the economy is going to reopen. So that's the first difficulty they have. But secondly, a lot of them don't have the skills, Ronan. That's the bottom line. Like they've never been called upon to produce detailed cash flow projections by store, if they have a number of stores, for example, in retail, right through to the end of the year, taking into account all of the variables that are there, the government supports that they might get, the subsidies, for example, holidays that they might get from some creditors, revenue, etc. It's a complex financial model that they need to produce, but they've really got to get a command of those numbers. They have to get on top of the numbers and do it on a reasonable basis, the kind of basis, like we said, like go back to 2012, 13, use those numbers, use those turnover figures, don't use 2019. And if you do that, I think when it comes to somebody looking back and say, what did you do to try and mitigate the risk? What did you do to minimize the losses to some of your key stakeholders, your key creditors? Did you actually plan? I think you need to be able to show that you did something, even if it's not perfect, and it won't be perfect, but you have to show you did something.
But Neil, I wanted to take you back to something you said earlier on in terms of one of the fundamental pillars of examinership, which is finding the funder to take you through. I might just go into that a little bit, because obviously there's two things that arise. Firstly, the practicalities of when do you seek the funder? Do you want your funder lined up before you petition for examinership, or immediately after you petition? And that's the first thing. And then secondly, I suppose it's the tricky question, which is, in the current environment, there are going to be fewer funders potentially than you would ordinarily find for a going concern. Would you agree with that?
And not necessarily, Ron. I'll tell you for why. There's 4 different ways you can fund an examinership or a scheme. Okay, the first and probably the best way is new equity investment, like new equity investors, and we'll come back to that in a second. Secondly, then you're talking about new financing, as in bank financing, or either pillar bank financing or else alternative lender financing. Now there is, as you know, the SPCI COVID loans that are available, up to $1.5 million, the first $500,000 unsecured, no more than 4% cost. There are a number of businesses that do qualify for that and can qualify now. And really the question, I suppose, that some businesses are now posing, they're saying, well, if I get my hands on that funding, maybe I should use it as a war chest to fund a scheme of arrangement, rather than pouring it into losses in the course of May, June and July, and then have the terrifying prospect of reaching the last 6 months and having no cash and having this mountain of debt. So, I mean, that's the issue in terms of the key obvious issue in terms of lender financing for schemes of arrangement is the SPCI funding. But then you also have a couple of other options in the sale of non-core assets. Some businesses are going to be consolidating back. They're going to be shrinking their businesses down. They may be able to generate a fund from the sale of assets which are deemed to be non-core. And that's something they may need to do. And then the final way of funding schemes of arrangement, probably the most challenged in the current environment, would be a trading surplus, in terms of businesses that, because of the particular time of the year, they happen to be busy. This is their busiest time of the year. Now, there's not that many businesses that are open that would be able to take advantage of that. So it's not really going to apply in this circumstance. It's normally, for example, retail businesses using the Christmas trade to fund a scheme of arrangement, as many retailers have done in the past, including the likes of Golden Discs, for example. They would have used the Christmas trade to fund a scheme. So, but going back to the equity investors, there was a lot of money available for projects just before the COVID crisis. So there was a lot of, some of the alternative lenders and investors chasing the same projects. It was just the way the economy had turned. Like that wasn't the case, obviously, a number of years ago. But I think that for those who are not it didn't come in a vulnerable way, that their portfolio, that I'm talking about investors now, that their portfolio is okay, they may well be on the lookout for opportunities. They may well be looking for businesses to invest in. So I'm not so sure it's going to be the same as it was back in 2009, 2010, when we obviously had the banking collapse and we had banks that just disappeared overnight. I think this is going to be different. It's going to look and feel an awful lot more. I think it's going to be more positive than the last time, where there was basically a 100 billion euro hole in the economy, which was, it was a permanent loss. It was a dead loss. I don't think that's the case in this instance. And we have a chance to bounce back from it quicker as an economy, and also SME businesses that find themselves struggling. They also have an opportunity to bounce back quicker if they take the right steps and if they do the right thing.
That's a very interesting response and a very positive one to hear. And then in terms of the practicality of directors thinking about funding or alternative funding as part of an examinership process, at what stage did they need to start thinking about that?
Yesterday. I'm not wrong. They should know by now. They should know by now what the lie of the land is. There's been 3 or 4 weeks now for this to sink in. And I think it is, we're going back to like what's a director acting reasonably and a director acting irresponsibly. We think that if they haven't actually got those projections done, if they don't know where that pinch point is coming, that's not being responsible, because it's not like a lot of businesses are closed. It's not like they don't have time to dedicate some time to getting this done. Likewise, there are grants available from Enterprise Ireland, for example, of €5,000 to get this work done, to actually employ somebody, to employ the likes of ourselves or another firm, to bring them in and do a turnaround plan, a business plan, like a COVID-19 business plan. And the local enterprises offices as well are likewise making available grants of up to €2,500 to get business plans done. So I think people should have that done already, frankly, or should be working on it right now, to be able to identify where the funding requirements are going to be and what that restructuring plan is going to look like for their business.
Very good.
Can I just ask Neil a little bit about what I would call book insolvency, in terms of like, again, I'm just thinking, I'm a director, I'm listening to this. You would imagine that everyone knows whether the company is solvent or not. But again, you have to assume that until 3 or 4 weeks ago, there's plenty of directors who the question of solvency never arose because it was trading perfectly. So how do book insolvent, like, how can I, as a director, know immediately whether I'm in serious trouble, or whether I meet the test even for examinership in terms of the solvency requirement?
Well, I think they're going to know. I mean, in terms of meeting their debts as they fall due, that's the key test, And the difficulty, I suppose, with a lot of cash flow businesses is that they tend to pay for last week's problems with next weekend's takings. In other words, whatever supplier pressure arose last week, they deal with it by making a payment from next weekend's takings. Now next weekend's takings just didn't happen. So therefore that long list of creditors has crystallized and now are all looking for money.
Do you have any sense on the ground? Are the creditors coming knocking yet, or is this kind of collective sense of togetherness and we'll get through this together holding? I mean, or is it gone?
That lasted about 3 or 4 weeks. I mean, the green jersey agenda is what you're talking about. Unfortunately, that kind of lasted maybe 3 or 4 weeks, and now everybody is out looking for money. And the big issue is going to be when businesses try and reopen. They have to actually go down through their list of creditors and say, right, to reopen, I need stock from X supplier, Y supplier, and so on. And I need to actually make a payment up front for that. And cash is going to be so thin on the ground at that stage. It's going to be difficult for them to get those suppliers to fund them, or to actually put stock up front. And that's where they're really going to see a solvency issue. They cannot make a payment on account even to get stock back in. Plus they're going to need, say, a couple of weeks of wages set aside to even get back up and running again. And the news coming through in terms of pubs, for example, from the Minister for Health, that's a really scary prospect, that it might even be longer before we start to see proper reopening of pubs. And that's, obviously it's a terrifying prospect for all of the members of the Vintners Association. So the solvency issue, Brian, I think businesses will know themselves as soon as they make that plan and say, right, what does it take to reopen? And where do I have the cash? Can I pay my debts as they fall due? The answer is going to be no for a huge amount of businesses in the state. And yes, the forbearance, okay, that only lasts so long, unfortunately, because in the end of the day, every business needs to get paid. That circulation of money has to keep going. So there's going to be a lot of pressure, especially in the months, I think, of June, July, August. There's going to be a huge amount of businesses under a lot of pressure at that stage.
Well, I mean, it's
Of
sort of
course.
it's sort of a domino effect, isn't it? Because if you ask for money from me, I have to pass it on, or like someone, and it's like
Yeah,
being on an airplane and someone puts their seat back, you have to put your seat back in, and backwards it goes.
exactly. Yeah, it is. It's like a merry-go-round. So it's the only answer is to try and get back to some sort of functioning normality. The state is doing what it can at the minute, but I think the missing piece of the jigsaw here is I think there's going to have to be some sort of reopening grant. I think they're talking about soft loans at the minute. I'm just not sure if that's enough. I think actually that, for those who took the hit on behalf of the state, and I'm talking about the pubs and restaurants and so on, like they really took a hit early on in order to try and save the health and save the HSE. I think that there has to be some per unit grant to assist in businesses reopening. And if there isn't, and it's a form of helicopter money, obviously, but if there isn't, I can see a lot of them just really struggling to reopen at all. They just won't have the cash flow to reopen. So that's something that's necessary, I think, from the government at this stage.
And of course, now you're talking about more and more of these crises coming to light in June, July, and August. Of course, 5 weeks in, we've already seen our first high profile examinership application. And I'm sure Brian was certainly segueing from airline seats into that story. So we saw the examinership application of Cityjet recently.
Yeah, that's right. And I think airlines are a particularly challenged sector, obviously, but also anything tourism related is going to be hugely challenged, like not just the airlines, but also the tourism businesses themselves. I mean, most agents, for example, travel agents, etc., they have just written off 2020. Like they're focusing on 2021 now. They're looking at damage limitation for 2020 and trying to rebuild their business in 2021. I'm acting as examiner myself of a couple of food distribution businesses, which it found its customer base, being restaurants, pubs, etc., it just fell by 75% more or less overnight. Their turnover just collapsed overnight. And we're in, and I would hope we'll be in a position to rescue those businesses. One in Dublin, one in Wexford. So, I mean, for me, guys, I must say it kind of feels a bit like the calm before the storm, because it's just kind of slightly surreal situation. You see so many businesses that are closed. You just know that they're going to struggle to reopen. You know that that's going to have a domino effect on other businesses. But yet, they're just, all of that work just hasn't just started yet. All of that kind of restructuring work just hasn't started yet. But it seems inevitable that it has to start happening, not just in airlines or in restaurants, hospitality, tourism, but like right the way across. It touches pretty much every sector. Very few sectors are doing well out of this. You might say some medical supplies companies, some of the logistics businesses, such as some of the courier businesses, for example, that are absolutely flat out, and they've seen 30%, 35% increases when people shopping online. So there are some limited sectors that are booming, but by God, it's so few compared to the ones that are suffering.
And can I just ask Neil then, I suppose I keep putting my director's hat back on, and what I see is the only time examinership necessarily makes the big news is when it is a massive one, a Debenhams, a Cityjet. So I wonder, do people think, well, examinership is for massive companies, not for me? Do you think there's a danger of that?
There is sometimes, because people associate examinership, I think, also with very high costs and high sort of, high court costs. But obviously back in 2013, the process was brought into the circuit court. So it is possible now to take circuit court applications right the way around the country. You don't have to travel to Dublin to take them in the High Court. I'm involved, for example, in Galway at the minute in a circuit court examinership, where the costs will be much more modest rather than a High Court examinership. So it's horses for courses. And again, that's a perception issue. Maybe there's not a full understanding of how that can work. So it's probably not for micro businesses, I would say that. But certainly for SMEs, the vast majority of examinerships in the last 30, 40 years, whatever it is, since 1990, so 30 years, the vast majority have been SMEs, and the success rate is particularly strong in SMEs. So Brian, that is I think a common misconception that exists.
So we've noticed in recent weeks that the UK Parliament has sought to amend certain insolvency legislation to deal specifically with this crisis. And we've seen changes in legislation across Europe dealing with support of various sectors, airlines, for example. In your view, is the legislation we have in terms of examinership robust enough to deal with the current crisis? Are there any changes that you might see or would welcome?
Yeah, I'm sorry, I do know that the CLRG has made recommendations to the minister in terms of changing examinership. We may see some changes over the next week or two in relation to that. I was asked for my opinion about that and as to what kind of practical issues there might be in terms of creditors' meetings, in terms of posting out schemes of arrangement to addresses which may not be open to creditors who may not get them, and the use of electronic means, email, etc. So that's all kind of feeding into it. But on the flip side, I must say, I have been in court in the last couple of weeks, and like the court system still is functioning. So it is still possible to avail of examinerships. And as long as the court system is open, I would have thought that still works. I don't know if is there a fundamental overhaul needed of examinership to make it into a more voluntary examinership type model? I'm not sure we're going to achieve that this year. I think that'll be too far reaching. And I think if the restrictions start to ease, it might become a bit more straightforward to just carry on as we were. A bit more time possibly would be useful, but then I've always had the view that 100 days plus 21 days to implement a scheme, it's 121 days, it's 4 months. I mean, if you're going to save a company, I think you're going to save it within 4 months. I know in Cyprus, for example, the equivalent legislation is 6 months. I think it probably is more or less okay, and I'm not certainly at the minute in the 3 cases that I'm working in currently. I don't see any major blocks to getting a successful outcome for each of those 3 cases, even taking into account the COVID restrictions.
Is there a case to be made for doing this now when you'll get a better scheme because, everyone is so desperate for money? Like let's say you wait and go into examinership 3, 4, when it's starting to rise again, would it be harder to get a scheme of arrangement across the line because people will be holding out for more money, or?
So I suppose this is the hypothesis that you should never allow a good crisis go to waste, that you should use it to deal with all of the problems you have there and then, because it's the best time to do it. I mean, that argument is I think is being put forward. I know that certain principals are thinking, okay, they're more likely to be less kind of hostile takeovers in examinerships because a lot of their competitors, for example, have the exact same issues that they have, so they don't have to fear that somebody will come in from the outside. Whether that's true or not, I don't know. I mean, as I said to you, we always encourage directors to rule nothing in and nothing out when it comes to the investment side of things, because companies in examinership need investment, so they can't rule anything out at an early stage. So I think it could well be. I think that the main reason why this is a good time to be looking at restructuring is because, like I say, everything is so calm. It's this kind of strange, serene calmness everywhere if you're walking around even the streets of Dublin at the minute. So it's a very sort of a well-organized, or well organized maybe is the wrong word, guys. It's just it might be a time whereby there's not so much panic. There won't be as much panic in terms of the actual business operation because of what's going on. It might be just a more straightforward time to reorganize. And the only thing is, guys, I'll tell you my experience though, businesses tend to need a push to go into examinership. It's, you know what I mean? There's always a trigger of some sort. It's either the company running out of money, can't pay the wages, or a sheriff walking in, or a receiver walking in. It's just human nature. People tend not to be so forward thinking as to plan exactly the timing of their examinership. And I think that's going to be the big challenge in getting cases on. They'll be in crisis before they actually do anything. In my experience, they tend to find themselves in a crisis before they actually push the button on examinership.
So I will let you go in a minute, Neil, but just that might be one point that is worth on a technical point for anyone who does find a receiver walking in. The issue of the possibility of a receivership effectively being set at naught or set aside, is it within 3 days, or there's a time frame? Yeah, so I think it can be easy enough. I would see it as well with food law, where there's a closure order that you have the option to appeal to the district court within 7 days. But, if a receiver walks in or if your business shut down, you're in such a flap that you mightn't necessarily get yourself together within 3 days. So I suppose the message would be, if you are one of these businesses and a receiver walks in and examinership is an option, pick up the phone fast, because you've got 3 days to move.
Yeah, the 3 days is so short if you want to get an independent expert's report and petition. I mean, it is possible to do it, certainly, but it's far, far easier to do it if you have it ready in advance. And I think it's less likely the pillar banks are going to be sort of appointing receivers, but there are a lot of loans still owned by funds which have no long-term interest in Ireland, and I think they could well have an eye for the main chance and see that this might be the time to seize the assets of a business which could close that business down. So yeah, it certainly is a very, very relevant point at the minute for businesses that are vulnerable because they've got too much debt.
Everything is suggesting the phone should be ringing off the hook. I mean, is the reality that they're just not yet? People just, they're not catching on to it. You said you've got 3 on the go at the moment.
Yeah, I've got 3 on the go, and I've got 3 more other kind of potentials, which if everything is frozen and mothballed, there's no cause, there's no trigger.
That push you were talking about.
Yeah, it's like they're like, okay, well, hang on a second, I don't really know what the hell's going on. So let's wait until I have to actually confront my reopening, or I have to ring my bank, or I have to ring the fund that I owe money to. I have to ring Goldman Sachs or whoever it is. And like, we're just in this kind of really funny sort of period of time. But there could be an enormous amount of restructuring work available in the last 6 months. And I mean, everybody I'm talking to is telling me you are just going to be out the door with restructuring cases. Like that's just what I'm being told. You know what I mean? Like people in the industry, my former chairman, the head of Retail Excellence Ireland, like they just feel that it just doesn't work. The economy doesn't work if it's just running along at 60% or 50%, because the cost base is set up at 100%. So if you've only got 50% coming in on the top line, it's a grim picture, do you know what I mean, from the economy generally. So this is going to be hugely important. I think examinership is going to be massively important in the next few months.
The procedural steps, if I'm a director and I've listened to this and I think, right, actually I need to look at examinership. Do I call my lawyer? Do I call my accountant? Do I call Neil Hughes directly? An independent expert report you mentioned, like who sets what up?
Just in practical terms, so really good question, Brian. In practical terms, people tend to come into our office. We have a look at it. If it seems like a good candidate, we will say to them, listen, you really need to get an IER prepared. It's just a short report from an independent accountant to just set out what the issues the company is facing, what the future prospects are, and critically, does the company have what's called a reasonable prospect of survival? It doesn't have to be a certain prospect of survival, just to have reasonable prospects of survival. So it's quite a low bar initially to get into examinership. And we would typically set that up for somebody. It can be the company's auditor, but we could sort of help them just getting that step in place. They then obviously need legal advice in terms of making a petition to court. So those are the practical steps. But the first step is to speak to the nominee as examiner, be that us or somebody else, and get an IER commissioned. Normally takes a few days to get that done. So that's the first step, Brian.
Can I just say there on that point, we spoke a little bit earlier about directors and the cultural disinclination to hold their hands up and say there's something wrong here. But in reality, putting your hand up to say there's something wrong is actually the braver choice. And that's really what directors need to look to do.
Yeah, that's the enlightened approach, is to put the hand up. So I couldn't agree more. And if people were to, if everybody that was found themselves in difficulty, he said 2% of companies go into examinership. The other 98% go into liquidation. I just find it astonishing that some of that 98% don't put their hand up and say, look, is there any other option for me other than just closing the doors and laying off all my staff? It's extraordinary in the last, the hundreds of thousands of jobs that were lost in the economy in the last 10 years that could have been saved. And I just hope to God we don't make those mistakes again in the next 10 years.